Sorry, you mentioned before that the worker not understanding why the claim's been accepted. I can't comprehend that. If the worker's not understanding why the claim's been accepted, how is the claim accepted?
What I'm talking about there is often the claim will have started. Is it possible to get that blind put down at the back? It's just a little glary. Often the claim has started under performance management. To take an example, we had performance management tied up in a nice neat little bow. The reason it was accepted was because the manager and the worker got into a fight, into an argument. Now the worker actually started that argument, but that becomes irrelevant. There was a conflict and there was a reaction. The worker though continues to believe that it's the other issues that were raised about they kept asking me to do this and they were talking to me about being late and they were doing all this, that the reason the claim is, because when they've lodged the claim, they haven't gone, oh, it's about this. They've put in what we call the hamburger with the lot claim, where they've listed a whole lot of things. So when the acceptance goes out, and Adam, I'll look to you on this, they don't actually sit there and say, this is why your claim is accepted. It's your claim for psychological injury has been accepted.
Correct, yeah. So is this on? Can you hear me? Yep. So the letter that goes out for advising a worker of an acceptance of their claim is, as Simon said, it's quite limited. It does basically advise the worker that the claim has been accepted because we're satisfied that they've sustained a work-related injury that entitles them to compensation. And it's a matter for the agent to discuss with the worker the finer details behind the decision. But something to bear in mind that's quite important is for a claim to be accepted, essentially what needs to be satisfied is that the worker sustained diagnosable injury that arose out of or in the course of their employment. So that's on the no-fault basis as well. So there's quite often a number of different factual elements associated with the decision, but those are generally discussed with the worker, but maybe that's where sometimes there can be a bit of gaps in the understanding of the finer details.
And just one more question, just with regards to actually identifying what the impaired worker is actually able to do. If you have a look at the certificate of capacity that what we currently use, it's just a box that's ticked for that there is, and also I haven't actually come across a medical professional, or very, very few medical professionals that actually know how to complete one of those. So how do we work with, I guess, these the medical professionals and the actual forms that we do have?
All right. A couple of things. One, under the Act, Section 113 allows you to have somebody assessed and it doesn't hit your premium. Okay? So that's a good start and you should do that relatively quickly. Secondly, at common law, where a person is not fit for the inherent requirements of the job and you have to ascertain what are the reasonable adjustments that need to be made under a case called Ramsey and Blackadder, you can direct someone to be assessed. What you can't do is, if you're looking towards termination, is use anything under the workers' comp legislation. You can't use Section 113, you can't use any of the evidence you've got. You have to have them assessed yourself. And that comes under what's called Section 22 of the Occupational Health and Safety Act, which gives you an obligation to monitor health. So if you're not satisfied someone's fit for work, Section 22 of the OHS Act says you must use expertise to ascertain what is a person's health status. And there's a case called Grant and OPP that says once you do that, you must disaggregate, break up, what a person can do, unaffected by the illness, that which they can't do and what you need to do, and create a plan so the supervisor who's managing them understands what needs to be done.
Yeah, so to develop the return to work plan, it's just hard for the medical professionals that are completing these at the moment. It's actually hard to actually develop that return to work plan with the information that's on the current certificate capacities.
Yeah, you're right, Joe. The issue is that if you try and rely solely on the medical certificate, a certificate of capacity, you're going to fall short. Right? It's absolutely, that is a tick-the-box document, and if you're going to rely on that, you're going to get a tick-the-box response. You need to go, as Andrew said, that step further, make further inquiries, deal with if it's dealing with a doctor or getting them assessed further, that's what you need to do. You just can't rely on the tick boxes. It's a problem, and particularly mental health, because the GP is not that skilled.
So is that something that I guess we need to put in with our onboarding or in our procedures, looking at, so I guess the employees understand that we will have, that we do have, well, not input, but we will be a part of potentially consultations, and that if the incidents arise, or
Yes, just as exactly the same as you would if they broke their leg. It is. We need to get to the point of it's no different. Mental health is no different to breaking your leg.
And look, if I can just say, there's two parts. When you're onboarding someone, my preference is always that you have someone assessed, okay, and you have them assessed against the job description, which is critical that job description picks up all hazards in the workplace, including psychosocial hazards. Your policies and procedures and the contract they sign should say that at any time you can direct a person based on reasonable basis to have a medical assessment or health-related assessment. So the person can't say no because they're required to. They enter into a contract that does that. Many of the enterprise agreements I do have that in the actual enterprise agreement to allow you to do it as well. So yes, you're right. Have a system that exists so everybody knows and apply it uniformly. Don't apply it because you don't like someone. Make sure that you do it correctly every single time, because that goes to the reasonable management action thing if you do it because you just don't like someone or you're angry with them.
You got any more? Yeah, in the front.
Looking at an employer, they're aware of mental health concerns in the workplace. They're aware, but they're not aware. So they feel like there's issues arising in the back end, but they're not conscious of how to address it. What are some of the what's a first step and an initial first step an employer can take to start action, some sort of action in that space?
Okay, so what we're seeing here is a manager starting to pick up primarily a change in behaviour or a change in performance. They're pretty much the two standardised areas where a workplace will actually establish whether something's going awry here. I mean, it leads back to what Jay and Andrew were saying in the beginning, and that is, the comment about managers and supervisors being obviously one of your best assets, but they can also be one of your biggest liabilities. And that is, how can you expect a manager to manage the way you want them to without showing them how to do it? I can guarantee that all of your employees have signed a contract under their clause of employment to make sure that they provide a safe, supportive and productive environment, because that falls under the OH&S Act. That actually includes psychologically safe environment too. It's in law. So to answer that would be to make sure that you are giving your managers and supervisors, firstly, the permission, because you've got a bunch of people out there that want to care, but they're scared to care, because we've drowned them in policies and they don't want allegations of bullying. They don't want allegations of harassment. They're terrified to breach privacy. So what I'm seeing and where I'm seeing employers really start to get traction and having managers have more courage and confidence to intervene is firstly giving them permission, letting them know that it is actually in accordance with our duty of care that you ask someone if they're okay, and giving them the skills on how to respond and then manage what that person might need, whether it's a workplace adjustment, whether it's a change of role, whether it's time off. We're not asking managers to solve people's psychological issues. The only responsibility of the manager is to have the skills to be able to provide a safe, supportive environment to allow that person to recover appropriately. So the answer to that is give them some training. Get someone into your building to show them what the proper way is to firstly intervene, have a conversation, and then monitor. And it doesn't have to be that complicated, more often than not, people are willing to do it. They just need your permission to do it because they're too scared to do anything wrong. Whereas, ironically, it's actually the best thing to do is to ask, manage, and monitor.
I think, as Anna says, the other thing to remember is since 2015, a case called Burke and Suncorp says that when a reasonable person would observe that a person has a health-related issue, they actually must intervene. So they actually have to do something, and it comes again under Section 22 of the OH&S Act. So this isn't I'd like it, this would be nice, but actually you must train people and you must give them the tools in the bag that say, if you're not an emotionally competent person like me, I've still got to have the conversation, but I'm going to go and say, but I'm going to get Anna to come and have a chat with us afterwards to help us through it. But you must have the conversation.
Any other questions out there?
We heard what a panic attack might look like, but what does a psychotic episode look like? Like, how can that actually? What is it sort of? I've never seen one, so I can't visualise it. So.
And that's the thing. I mean, the question was, you know, what is a psychotic episode being acute or major look like? The response to that is how long's a piece of string, because not everyone has the exact same reaction. That's the frustrating and grey area of psychology. But where they term something under the diagnosis of psychosis is basically where they're starting to lose mild or extreme touch with reality. So one of the things that's almost ironic in a sense is that it can be easier to identify a psychotic episode than it can be a panic attack, because what you'll see is quite overt signs that will sit into your strange radar. And I mean that with all due respect. They'll start to say things that are disjointed. You'll be sitting in a meeting and they'll say something that is absolutely irrelevant to what's happening. Their appearance will change. It'll become quite overt. So don't be too concerned about not knowing, because when it is happening, it actually becomes quite obvious. And very rarely does a psychotic episode happen instantaneously. There's a build period. And if you talk to anyone that has psychosis, they're often quite aware of their own signs as well. It's just not their choice about where their sense of lucidity starts and stops. To give you a sense of comfort though, people with psychosis will generally declare before employment. Psychosis is normally founded and established very early on, primarily between the ages of 15, sometimes younger, up until 20. So it's normally quite an early onset of a condition, for the exception, of course, of drug-induced psychoses. But primarily those people that have had psychosis have been managing it for a very long time and are actually really comfortable with it. It doesn't really it sits heavily in the stigma area, but not for the person that's suffering it. And that's why there's such a large unemployment rate with people with psychosis. So when they're, I guess in their terms, when they're lucky enough to get a job and hold it, they will declare it. And they'll quite often give you what's called a directive plan anyway. So this is what I need you to do if I happen to have an episode. So most people will have that. But yeah, to answer your question, it will look like something completely out of the ordinary, from a mild case of just slightly changing in behaviour to speech to decision making to memory loss to major, and that is where we're introducing delusions and hallucinations. So that's when, you know, they'll actually start to be quite overt in behaviour.
What sort of question can we ask? How do we pose the question to them about pre-existing, schizophrenia, manic depression, that sort of illness?
Yeah, you should have a form which comes under Section 41 of the Act, which allows you to require someone to disclose any pre-existing injury or illness. It should be done through a statutory declaration. There's a case called Toll and Alice, which says that unless it is brought home to the person that they must fully disclose, and it must be an informed disclosure, it won't be sufficient to terminate someone's employment, because to do it falsely would be serious misconduct, and it also means the insurer would not indemnify an injury that arose, which is a continuation of that injury or illness, unless it's an aggravation that came from it. So the important part of that is you must have your job description accurate. It must be what's I'd call a principle-based job description that describes the elements of the job, including all the hazards, both physical and psychosocial. And the person should be advised that to answer this, they may need to go and see their own doctor to fully answer it, and it must be accurate when they answer it. And if they don't disclose it accurately, then it has an insurance impediment for them, and it allows you to terminate their employment. It's only available in Victoria and Queensland. In other states, you have what's an inherent requirements disclosure, and that's one that falls under discrimination legislation, and it's a much more cautious process of doing it.
And just to add to that, if you've already employed them and they've got their forms to fill out, go back one step. When you're interviewing someone, you can ask. It's just their decision whether they need to disclose. They don't have to disclose by law. But what you'll be surprised about is the amount of people that will actually be quite humbled by the fact that you've asked, because you're setting a precedent to say, okay, we actually give a very damn big hoot about mental health here. And if you've got any pre-existing conditions, we'd love to know about it so we can create a safe workplace environment for you. Some people will be like, nope, not saying a word, I want this job. And other people will be like, great, I've actually never had an interview that's opened it up that way, and a lot more people will disclose. So even think about taking it back to how you're recruiting. I really, and I can't emulate enough identifying the hazards, because you can get some great people into roles, but once they start to feel pressure, they crack. So you can actually justify why you ask. If you've got any pre-existing conditions that may impact your ability to perform this role, let us know. But obviously by law they don't necessarily have to disclose. But it all depends on how you design your interview process and how comfortable you make them feel. You'll start to get better traction with candidates. And one of the things that, that I work heavily in is discrimination, and people are like, nope, no way, wouldn't hire someone like that. So you've got two candidates, right? One that says, yep, been battling depression for 10 years. The other one's like, nothing wrong with me. But 2 years down the track, you know that, you hire the person that, doesn't have the mental health condition that they may not necessarily disclosed, and then you're in hot water. You enter into the long-term complex claims because you never knew about it. So that's how I turn the table on employers and go, if someone was bold enough to declare a mental health condition to me and it was managed and they're getting treatment and so forth, they could turn out to be the best damn employee you've got, because you know what to expect and they know how to control it, rather than someone not disclosing and then you dealing with it in a more reactive sense later on.
Can I just add to that? Anna's words are really critical. It's only as it relates to the inherent requirements of the job. So when you ask that question, say, look, please don't tell us about an illness or injury which has nothing to do with you doing this job, because we don't want to know that that's your business. It's an exception to privacy law. You are entitled to ask in relation to health-related status the inherent requirements of the job. But by being respectful and asking, as Anna said, it's a great thing to do. Okay? Just don't ask, so do you have any psychiatric injury that we need to know about? Because you just need to make it show them that you're being respectful as to this job goes. And that's why I said the most important thing you can do is update your job descriptions so that they are accurate both physically and psychologically, so people can properly respond.
I just want to back up one thing that Anna just said, and this is really, really important from my point of view. We all preach early intervention, right? We all preach in the event of an incident, in the event of an injury, early intervention is the strategy. If someone is going to be open enough at interview stage to say that I occasionally suffer from this thing, whether it be an emotional issue, a psychological condition, or an occasionally dodgy calf, they're the ones that are going to come to us early and talk to us about the issue as it starts, and we can get involved and we can be there. Don't be afraid of the person that tells you about their problems.
All right, we seem to have run out of time. I'm sure